Double Quickie, 1982's Oregon v. Kennedy. It's another unanimous Supreme Court case that abrogated one of our basic constitutional rights, protection from double jeopardy. Bruce Allen Kennedy was charged with theft of an Oriental rug. The case was declared a mistrial when the prosecution asked the state's expert witness, "Have you ever done business with the Kennedys?" The witness replied, "No, I have not." And the prosecutor said, "Is that because he is a crook?" So the state of Oregon tried to retry him, and Kennedy claimed that they can't because double jeopardy attached to the mistrial since the jury had been seated and the first witness called. The Oregon Court of Appeals ruled in his favor. Double jeopardy applies to a mistrial that's the result of prosecutorial misconduct or other bad faith conduct by the judge or prosecutor. And that had been in line with precedent up to that point. They said he'd been given a Hobson's choice, either to accept a necessarily prejudiced jury or to move for a mistrial and face the process of being retried at a later time. But the Supreme Court overturned it. William Rehnquist delivered the opinion where he said that double jeopardy does not attach to a mistrial due to prosecutorial misconduct, where the prosecution was merely trying to win, only if they had the intent of goading the defense into calling for a mistrial. Funny, that part's not in my copy of the Constitution. So I guess you have to read the prosecutor's mind? Or just take his word for it? At any rate, what's the difference? It's the same effect either way. When government uses underhanded tactics to try to win, it means they already know they have a losing case. By the time the trial begins, all of the evidence is in, having been accepted or excluded in pretrial motions. At that point, if even the prosecution isn't sure they'll prevail on the merits, doesn't that mean reasonable doubt? And if prosecutors knew that this kind of misconduct wouldn't get them a second bite at the apple, wouldn't that discourage them from doing it? When the government feels they have to cheat in order to win, the proper course is a mistrial, and double jeopardy should absolutely apply because the government was given a chance to present its evidence and they chose antics instead.